This is an OSHA training for Boise School District supervisors regarding filing whistleblower complaints under the Safe Drinking Water Act. As a supervisor, you need to know that employees are protected from retaliation for reporting alleged violations regarding all waters actually and potentially designed for drinking use, whether from above ground or underground sources. The Safe Drinking Water Act, or SDWA, prohibits employers from retaliating against employees for engaging in protected activities pertaining to alleged violations of actual or potential drinking water from above or underground sources designed for consumption. This means that you may not retaliate against an employee in any manner because they 1. Provided or are about to provide information relating to a violation of the SDWA to the EPA or other appropriate federal agency, or 2. Testified or are about to testify in any such proceeding, or 3. Refuse to perform duties in good faith based on a reasonable belief that the working conditions are unsafe and unhelpful, or 4. Participated or assisted in a proceeding under this statute. If you make an unfavorable employment action against an employee and that action is motivated in any way by one of the protected activities described in the previous slide, you may be found to have violated the SDWA. Such actions may include firing or laying off, blacklisting, demoting, denying overtime or promotion, disciplining, denying benefits, failure to hire or rehire, intimidation, making threats, reassignment affecting prospects for promotion, or reducing pay or hours. If someone wishes to file a complaint under the SDWA, it must be filed within 30 days after the alleged unfavorable employment action occurs, that is, when the employee is notified of the retaliatory action. An employee or representative of an employee who believes he or she has been retaliated against in violation of the SDWA may file a complaint with OSHA. Complaints may be filed verbally with OSHA or by visiting or calling the local OSHA office, or may be filed in writing by sending a written complaint to the closest OSHA regional area office. Complaints can also be filed online at the below URL. No particular form is required, and complaints may be submitted in any language. Upon receipt, OSHA will review the complaint to determine whether it is appropriate to conduct a fact-finding investigation, and all complaints are investigated according to statutory requirements. If evidence is found in the resulting investigation that supports an employee's claim of retaliation and a voluntary settlement cannot be reached, OSHA will seek relief to make the employee whole, including payment of back pay with interest, compensation for special damages to include attorney's fees and other expenses the employee may have incurred as a result of the violation, punitive damages, or reinstatement. OSHA's findings and order become the final order of the Secretary of Labor unless either party objects to the findings within 30 days. After OSHA issues its findings and order, either party may request a full hearing before a Department of Labor Administrative Law Judge. Their decision and order may be appealed to the Department's Administrative Review Board. You can access a copy of the Safe Drinking Water Act, the regulations, and other information at www.whistleblowers.gov. OSHA's Whistleblower Protection Program enforces the whistleblower provisions of more than 20 whistleblower laws. To learn more about the whistleblower statutes, which OSHA enforces, view the Whistleblower Statutes Desk Aid at the below URL. If you have any questions regarding this training, please contact Human Resources. If you have any questions or need more information from OSHA, then go to whistleblowers.gov or dial the number below.